Welcome back to the Constitutional Clarion. Now, at the special request of one of my viewers, I'm actually doing another video about the voice. I thought I'd finish, but apparently there are more issues. So in this particular case, a viewer has asked about whether or not the proposed amendment would actually guarantee the continuing existence of the voice. And this viewer pointed out about the provision in the Constitution that refers to the Interstate Commission and says that it shall exist, whereas actually it doesn't. So, shall we talk about that mystery? Now, the first thing to point out is in the proposed amendment, section 129(1) says that there shall be a body to be called the Aboriginal and Torres Strait Islander voice. But that voice can't exist in practice in any meaningful way without human beings who comprise it to be able to exercise its powers. And in order to get that, you need to look at section 129(3). And that says that Parliament is the one that makes a law to comprise the body of certain people, so to work out how they're chosen, are they elected, are they appointed, where do they come from, what are their qualifications, all those sorts of details, and all the details about the way it operates. So, the first question I was asked was, well, what would happen if the referendum passed, but Parliament then didn't enact the law? Could a court then come along and say, Parliament, you have to enact that law? Now, the answer to that is no. Why? Well, it comes down to something called a duty of imperfect obligation. And that means sometimes the Constitution tells us that we have a duty to do something, that we have to comply with the Constitution, but it makes it an obligation that is not one that's enforceable by the courts. So that means it's an imperfect obligation in that you can't go to a court to legally enforce it. It's an obligation that relies on political or moral obligation. It is something that you are supposed to do and you should do, but not something that's legally enforceable. So let me give you a couple of examples. If you look at section 53 of the Constitution, you'll see it says that the Senate can't originate a bill that imposes taxation on the people, and also that it can't directly amend a bill. Now, that provision, again, is one that's not enforceable by the courts. The only way it can be enforced is by the houses themselves. So it's an internal proceeding of Parliament that Parliament has to comply with, but it's not one that a court can come and impose, because that would lead to the court interfering in the internal business of Parliament. And the Constitution tries to keep the courts separate from the Parliament. The second example is the High Court. So section 71 of the Constitution says this. I've got my trusty Constitution here. It says that judicial power of the Commonwealth is vested in a federal Supreme Court to be called the High Court of Australia, and that this court is to consist of a Chief Justice and so many other justices, not less than 2, as the Parliament prescribes. So again, we're sort of creating a body, but it can only come into actual existence once you legislate to provide for that. And it's up to the Parliament to decide, how many judges are on it, etc. In this case, they give a minimum, a bit like creating a voice and deciding how many people are on it, blah, blah, blah. Okay, so again, obviously not the High Court, because it couldn't come in and force the Parliament to create the High Court, a bit of a chicken and egg problem there, but could one of the other courts have forced the Parliament to enact the law to create the High Court? And again, the answer is no. It's not the business of the courts to force Parliament to enact legislation. There's no positive obligation to do that. It's a matter for Parliament and its internal proceedings to decide how it operates. And so Parliament can, and indeed did, enact legislation to establish the High Court, and that was in the Judiciary Act in 1903, so it took a couple of years for it to actually manage to do that, because again, it was quite complex legislation. This would be similar again to the voice. It probably would take a couple of years to negotiate and work out the terms of the legislation before enacting it. So that's not unusual. If, however, you came along later and said, now I want to repeal that legislation and get rid of the High Court, could you do that? Well, I don't think so, because that would be enacting a law in breach of the terms of the Constitution, which effectively require the High Court to exist. Now that then takes us to this odd beast called the Interstate Commission. So originally the idea was, look, there are all these problems in between free trade states and protectionist states, about states favouring trade within their own jurisdiction, and there were problems with preferential railway rates, so the amount you charge for goods to cross state borders, etc., etc. And because of all of that, the framers of the Constitution decided that they should have some kind of a body that had a mixture of powers, so it could investigate what was fair treatment of free trade, and it could also enforce it by adjudicating upon it. And so they decided to put this special body into the Constitution. It had no precedent anyway. It was a new made-up thing, and this is what it says again in my Constitution. Section 101. There shall be and that's where we took the words from for the voice amendment. So same thing here. There shall be or in this case, an interstate commission with such powers of adjudication and administration as the Parliament deems necessary for the execution and maintenance within the Commonwealth of the provisions of the Constitution related to trade and commerce and of all laws made thereunder. Okay. So this body was supposed to have those kinds of mixed powers. Now, the first interesting thing is it took quite a bit longer for Parliament to legislate to set up the Interstate Commission. There were a number of reasons for that. One was it was going to be costly. There was a bit of a crunch in terms of funding at the time. It was seen as a bit of a luxury. And the other problem was political, actually getting it through the Parliament. So 2 bills were initiated to do it, and one way or another they fell over. So the Interstate Commission wasn't actually established until 1912, so it did take a while. But then the catastrophic problem it faced was in 1915 when someone challenged the judicial powers that were given to it. So remembering it was to deal with a mixture of both administration and adjudication. And the High Court held, surprisingly, that it couldn't exercise judicial powers because it wasn't a court with judges who had tenure, etc., under Chapter 3 of the Constitution. Long political story about why the High Court judges said that. The people who'd actually originally put it in the Constitution, like Edmund Barton, in dissent, and the person who opposed it during the Federal Constitutional Conventions in the 1890s, Isaac Isaacs, is the one writing the majority judgment to effectively kill it off. Okay. Anyway, the effect of that was to gut the Interstate Commission, because once it lost its ability to enforce its decisions, effectively it just became a sort of an ongoing Royal Commission inquiring into the fairness of trade things, didn't have enough work to do, wasn't actually achieving anything. And so the consequence was it ended up with no one supporting it. Everybody thought it was useless. And it just didn't have enough work to do, and it wasn't achieving anything useful. So what happened in the end was after there were fixed 7-year terms for its commissioners, and when they expired, they were never renewed, and it was put into what someone described as a state of, just trying to find the words here, a state of suspended animation. Okay, so the poor Interstate Commission was in suspended animation. And yeah, there wasn't much animation, and it nominally continued on in existence until someone finally pulled the plug by repealing the legislation in 1950. Now, there was a short revival of its existence, initially abortive, so the Whitlam government tried to revive it, but that was thwarted when the Whitlam government was dismissed, and then the Hawke government in 1984 did actually revive it for a period of time. But by 1990, what happened was its actual functions were sucked into another body, the Industry Commission. Now some of those functions are done by the Productivity Commission, but the Interstate Commission itself again suffered a second legislative abolition. So you ask yourself, well, hang on a minute. You said at the beginning that you couldn't force courts couldn't force Parliament positively to enact the law to create the body, but once it was created, then any legislation that tried to abolish it would be unconstitutional and struck down by the courts. Now that's true, except for the fact that nobody actually ever challenged the abolition of the Interstate Commission. And if they had, they might well have won. But the point was that there was just no constituency for it. Nobody wanted it to exist because it was completely useless. Okay, so taking that now to the voice, and how does this affect the voice? Well, in answer to the first question of, what happens if Parliament doesn't ever enact the legislation to create the voice if the referendum is passed? Well, the reality is, if the people in a referendum have told politicians, we want you to do this, politicians will. So there's the political imperative there. It's a duty of imperfect obligation. The High Court can't come in and force Parliament to enact a law, but the political pressure of the people in voting in a referendum will force Parliament to bring that into effect. So yes, there will be legislation. But again, it may take a while. Maybe the current government brings up a bill, it gets blocked in the Senate or amended in the Senate, and maybe it doesn't get through this Parliament and you might have to have another go. That's all possible. But ultimately, politicians will know, if the people vote for this and the referendum is approved, that there is a mandate for doing it and that it has to be done. Second thing then is, well, if it exists, the voice, can a later Parliament come along and just abolish it? Can you legislate to wipe it out? And the answer here is that if you did, there would be a constituency of Aboriginal and Torres Strait Islander peoples who would go to the High Court and challenge that legislation and say you can't repeal it, unless of course you're replacing it with another body that, called the same thing, that has the same function, that you can't legislate to abolish it because that would be contrary to the requirement in the Constitution for it to exist. So yes, it's a trifle more complex than the simple assertion that this provision would guarantee the existence of a voice. It is the case that you'd need legislation to bring it into effect and a court can't force you, but politically there would be an imperative to make it. And equally, if someone, a later Parliament legislated to abolish it, if you got to the same point as the Interstate Commission where no one actually wanted it to exist and no one went to a court to challenge the legislation that repealed the original legislation creating the voice, then maybe the same thing could happen as in relation to the Interstate Commission. And frankly, if we got to that point, well, that would be fine, because if nobody wants it there, then why not let it drop? Okay, I'm assuming, however, that there will be people who want it there. There would be litigation to preserve it. It would be effectively guaranteed. And again, the last point to make is that guarantee is only for so long as the provisions in the Constitution. If for some reason the overwhelming majority of the Australian people wanted it gone, then you can always have another referendum to remove it. Okay, that's it for the Constitutional Clarion this time. I will hopefully see you next time, and if you do have issues that you want explained, feel free to email me and I will do my best to answer them. Thanks very much. See you next time.